Good evening, members. Now it is a chilly evening, and at the time of making this presentation, it was on a Sunday. Welcome, Mr. Chedwick. So let us jump in straight to the current affairs 2026 and various decisions that have shaped various jurisprudence here and there. And now, because of the quorum, I will have to go deeply to what I had prepared as compared to testing your knowledge, because most of the content here are in fact articles from news materials, decisions that perhaps you could not have interacted with them. So I will do the quick overview so as we save time under the 2 hours category. So under the current affairs for 2026, I saw this article being relevant because it notifies a student that the Finance Act of 2026 has taken place, and during this interview, there were some critical issues that arose. Honorable Bandi clarified about the Safaricom Vodacom diversity chart, and the host asked him about the potential legal risk of the deal being reversed by the High Court and the associated costs. And in that response, Honorable Bandi said that they have already completed the merger part and the acquisition part, and there is no legal barrier as it stands today. And he clarified about the 55% that the Vodacom intends to acquire. He also clarified that the issue on data privacy. He said that if you look, for instance, Airtel is controlled by a foreign entity, but they have never misused any data that is owed to them that belongs to the Kenyan regime. And the justification that he had is that there is a Data Protection Act that has stipulated how data that has been obtained from various entities is to be used. So that is what Honorable Bandi clarified. Then the other thing that you may not know is that the funds that are being gotten from this deal, the Vodacom and Safaricom share deal, these funds are going under the fund known as the National Infrastructure Fund. So I hear there is a member who has joined. It is Kista. So Kista, because of the ratio when it comes to asking a question, and the same are current affairs, I've decided to take an approach where it's like I'm reporting because it is something existing online. How is that idea? I should take the position that I put you on your toes together with Chedwick. Any proposal that you make, I'm willing to comply.
On the case laws?
And not generally, nime combine current affairs and the case laws.
I think since it's something that is there, you can maybe say report, and then kama kuna mtu mwenye ako na something to add, they can raise their hand.
Okay.
And they get to put like na structured information.
Nakupata. Alafu pia I also wish to put it to you that kuna times naweza taka pia kusikia your views, so naweza uliza hiyo swali tu ikifika kwa utumishi guys, I'll ask questions deliberately jiko na criminal element part. So Morris pia welcome to the meeting. Now the funds that are going to be utilized by this deal, Safaricom and Vodacom sell, is going to be utilized under the National Infrastructure Fund. And now there is a technicality here. This National Infrastructure Fund has no board members. It only has a council member, and it is chaired by Honorable Bandi. And Honorable Bandi has clarified the effectiveness and transparency of the utilization of these funds will not be spent before the board has been constituted. So currently there is a council. I see now we have a quorum. So maybe the questions that I had, I'll lay it down to you members so that you also attempt from your end. So I was clarifying because Martin and Morris, you have joined us now. These are the current affairs and decisions that have shaped 2025 and 2026, but majorly in 2026. And I've started directly with this interview where Honorable Bandi was put on spot to confirm some key details in regards to the budget and also the Vodacom sale. Some issues were being raised by the public. So up to this point, I would like maybe to pose a question to you members on how the National Infrastructure Fund is going to be utilized, and why did this fund not go to the consolidated fund? Why did they decide to take the proceeds of the Safaricom Vodacom sale to National Infrastructure Fund as compared to the consolidated fund? Yes, Mr. Chadwick.
Okay, sorry. I wanted to say that maybe, I don't know how many current affairs you have, but I was thinking maybe so that since members are joining, and maybe we can take like 30 minutes just to discuss the current affairs, and then after that we ask questions now. That's my suggestion, so that by then I know some members will have joined and we'll have maybe a good number.
I also agree with you, Mr. Chadwick, but the moment I project my screen to you, you'll already see the issues that I've outlined, even the answers that I have addressed, because I'm expecting a position once where we have discussed like the scenario before you, then I reveal the answers, then we will have finished with that segment. There are not many current affairs, ni the critical ones. Okay, so like for this instance, I've asked you directly, why is the Vodacom Safaricom funds not being sent to the consolidated fund? Why is it being sent to the National Infrastructure Fund?
Okay, maybe if I can try, I'd say that since the National Infrastructure Fund was enacted this year, so the main purpose of the funds, or like was to finance mega government project to also prevent issues to do with borrowing. So the main intention of selling, the government wanted to raise money for various projects without depending on foreign funding. So I think one of the main reasons was these funds were transferred there for specifically for purposes of implementing some of the government policies that had been put in place. So I do believe this is one of the major transactions that the government is doing since the coming to force of this act. So I would answer it in that way.
Thank you so much, Chadwick. You have given the rationale of why they are doing that, but the answer is there is a National Infrastructure Fund Act that was enacted, and it is that act that lays the foundation of diversitude proceeds to be sent to that account. So that is it. Now, another preliminary issue that also arose from that interview, we had something to do with when it comes to this first part of the interview. Before you, we had some policy and legislation matters arising, and one of the key details that I want to ask you, because it will be also tested during the tax procedures sessions. What is tax amnesty, or rather, give me various types of tax amnesty that are applicable in Kenyan law? That also forms part of the commercial transaction unit when it comes to the taxes part. Do you have any form of tax amnesty at the back of your fingertips? If you don't, you will pass, then I'll give out the answers. Then still on the same thought, yes, give me various types of tax amnesties. Because the reason why the rationale that I'm giving is that if you read the Finance Act that has now been operationalized, it is giving a 6-month tax amnesty. It is giving a 6-month tax amnesty starting 1st July. It started 1st July for taxpayers with arrears. So on that line of thought, what kinds of tax amnesties are usually available, and they are even documented in the law? Okay, I'll take it as a pass. Let us see the answers. We have tax debt penalties. This is provided under section 37E of the Tax Procedures Act. Remember, we were told to analyze the Tax Procedures Act in its totality. So what is it? This is in brief. It says that if you had an old tax debt, the government offered a window where KRA will forgive penalties and interest on those old debts. Then this means that you must pay the main tax amount because you have only been waived the penalties and interest on those old debts. Now, how do you qualify for a tax debt, a penalty waiver? You qualify if you had already cleared the principal tax by 31st December 2022 and KRA should stop chasing penalties and interest on that debt. But if you're not cleared principal by then, you could still get the penalties or interest waived only if you applied and cleared the principal by 30th June 2024. So the main goal is not for you to capture all these details. The main goal is for you to understand the various brackets that form part of waivers that KRA can give you a certain waiver. So that is one example under section 37E. The other example that you should take away is what we call voluntary tax disclosure programs. This is under section 37D of the Tax Procedures Act, and it basically tells us that a Come Clean program is where you tell KRA about past taxes you didn't pay or you underpaid, and in return KRA will forgive the penalties and interest fully or partially depending on timing. So the principal tax you should still have paid the same. So that is the second category of a tax waiver. Then you have another tax waiver known as foreign income repatriation amnesty, pursuant to section 37B of the Tax Procedures Act. This is a special one-off deal aimed at people who had money earned abroad that they hadn't declared in Kenya. If they declared it and brought the money back to Kenya within a certain set window, KRA will not charge tax on that foreign income for that specific period covered. So that is the third example of a tax amnesty applicable in Kenya. Then we have lastly the growth segment listing amnesty provided under section 37 of the Tax Procedures Act, and this is basically an incentive for companies to list on the growth segment of a Kenyan security exchange. If the company lists and cleans up its recent filings, then KRA will forgive penalties and interest for years before the listing. So when we'll be doing an analysis of the Tax Procedures Act, we will go into the details of how you even apply for a tax amnesty, because it is a procedure and it can be tested on its own. So those are the considerations that we will have to analyze. Then in my notes still I see another consideration, but it is not an amnesty, where we call penalty or interest waivers, and an example was seen in the section 69B of the Betting and Lotteries and Gaming Act. That I believe this is the one that was, this is the current one, because we had a betting act that was repealed. Now Betting, Lotteries and Gaming Act came into play. So this is not a public amnesty window for everyone, but a rule that lets the tax authority waiver or reduce penalties or interest if you apply and justify why you should be forgiven. So I believe this is a reiteration of the first one. It now gives you a practical example where the same was applied in betting situations. So that was it. So that's how I wanted us to analyze the same. Now, when it comes to the second segment, there is a news article saying that some Kenyans are being repatriated from South Africa. So I want you to tell me whether the Kenyan, whether this, you can just summarily tell me the legal issues arising from such kind of a news article when you are a Kenya School of Law, a student. What comes to your at the back of your head when it comes to anything that any information that you want us to capture? Just tell us something when it comes to this kind of an activity. Yes, proceed, Chedwick.
Okay, I'd look at it in terms of maybe diplomatic relationship between Kenya and South Africa. let's say considering that Kenya and South Africa have enjoyed a particular relationship, so maybe discussing on in terms of how Kenya can maybe, let's say Kenya can retaliate by repatriating the South Africans who are in Kenya as well, or because this brings about tension between two countries. We have seen Nigeria has started sending South Africans back to their country. So I'd look at it in terms of maybe the international conventions, or maybe the in terms of freedom of movement of people. So I'd analyze it in that point, and maybe in terms of diplomatic immunity, particular embassies within South Africa.
Thank you so much, Mr. Chadwick. Now, yes, Mr. Isaac.
Yes, thank you. The issue going on in South Africa, which is described as xenophobia, I could look at it from a legal angle of extradition, because those who are being chased from South Africa are illegal immigrants. So I don't know the position of South African law, but I could imagine that illegal immigrants could be treated as a crime. I'm not sure about that. So if at all it's a crime, and they have decided to chase them away, if you have been following, you have seen that there are sort of some demonstrations which are not are people oriented. It's the population, the general population, that has come up and decided to chase foreigners away, those who are not documented. So if at all that could be a crime, as it is in Kenya, because in Kenya, if you are not documented as a refugee, if you are in Kenya and you don't have papers, it's a crime. So if at all it's a crime in South Africa, then I could look at it from a legal angle of extradition. If a Kenyan commits a crime outside the territory of Kenya, which jurisdiction of the criminal procedure could take its course. So that's the legal angle that I could imagine of. Thank you.
Thank you so much, Mr. Isaac. Yes, Mr. Martin.
Thank you. I think I'll also look at it from two perspectives. One, from free market. Yes.
Martin, your voice is low. Your volume is a bit low, kabisa. We are struggling.
Okay. Now can you hear me?
Yes, now you are audible.
I'm audible, eh? So basically, what I'm saying is that I'm looking at it from two perspectives. From the free market, Africa is trying to be able to get to. Then also, I'll also be able to look at it from the Banjul Charter, where we say you need not be extremist. And also, even if this idea we make is not prevented, or whatever reason, I'll also be able to look at it from the non-enforcement angle. That is, the event that maybe probably there could be some displaced migrants who probably left the country.
Well, Mr. Martin, we are very apologies. Huko yani una struggle kabisa, una break, you are low. I believe maybe other members can also comment is Kweni from my end.
Okay.
Hello, fellow members. Can you hear Mr. Martin akiongea?
No.
It's all right. I can pass on. Can you hear me now? Is it now? Okay, I can pass on.
Unaanza vizuri alafu kuna mali una struggle ni kama the device that you are using haiwezi maintain your volume.
Okay, just hold on, let me try something and see that it's gonna work. Not I will hold on. Let me see.
Okay, now can you hear me?
Good, good. Yeah, now you are very audible.
Okay, I was saying that I will be able to look at it from two perspectives. Number one, from the free market, the Agenda 2063, that it means that the South African government has an obligation to be able to promote the Agenda 2063 that is supposed to guarantee some freedom of movement of people. Then also, I'll also look at it from the immigration perspective, forced immigration perspectives. Because I want to imagine some of those foreigners could have come from countries that have war, and for the fear of being executed, and then they have come to seek for refuge. So the non-refoulement perspective, I'll look at it from that perspective. But more so, I'll also look at it from, like what Chadwick has said, we need to be able to look at it from the diplomatic perspective. But also remember, if you look at what is happening in South Africa, it's a bit unique. Why? Because number one, for them, the government has not been able to come up with a clear policy, So it is actually the public, the locals who are going out to flush out anybody who they think is a foreigner. And for this case, they are looking for the black foreigners, not even the Muslim foreigners. So I'm trying to imagine that these guys who came from was it Palestine? I remember there is a group of Palestinians who went and sought refuge into South Africa, and we have not seen any of other colored people besides the blacks. So I think I'll look at it from that perspective, that kind of discrimination, because these people are also losing their property. So I'm expecting that the government is going to be able to seek a distribution, so that these people can be paid, compensated for the businesses and the livelihood that has been been disrupted. Because I want to imagine there are people who, irrespective of the fact that you are properly documented, but the fact that it's the locals who are flashing you out, your business is being rooted, closed down, then you have those losses that you need to be able to look at. Thank you.
Thank you so much, Mr. Martin, Mr. Isaac, and Mr. Chadwick for your contributions. Unless there is another member. From my end, I decided to incorporate a Kenyan decision. I'm looking at it from the Kenyan side, where the country is trying to restrict suspension for people to leave out the country. And in the case of Kohesh agencies and 32 others versus Minister of Foreign Affairs, we saw a position where the court allowed the government's move to prevent or to issue temporary suspension of recruitment or exportation of Kenyan domestic workers to the Middle East. So this is one of the predictions where the Kenyan government can also decide to put a temporary suspension for Kenyans going to go to South Africa for their own safety. Then secondly, I will tell the panel that if this situation is to arise in Kenya, we have a law known as the Kenya Citizenship and Immigration Act, and I'm looking at it in the angle where these people are coming to Kenya with no papers, so they have been chased. The Kenyan government has tried to help them, and they have even paid for their transportation cost. So when they come to Kenya, when I analyze this Kenya Citizenship and Immigration Act, there are some facilities to accommodate them. Then there is an exception that if you prove that you are a former citizen of Kenya and you don't have any documentations, you can apply for a new documentations with that exception and you will be granted. So those are the essentials that I will tell the panel to indicate that we are aware that we should protect the Kenyan immigrants that are coming from the South African region. Then this one is a big one. Utumishi Girls Academy. Utumishi Girls Academy is a big one because I decided now to narrow down to various issues that I want us to address, and I will read out the issues. The issue number one is on age and criminal responsibility. You list down the age, the criminal age, where it is the minimum recognized age for children. Then you give us issues to do with procedures when it comes to child justice procedures. What should you consider as a magistrate when you are dealing with child justice matters? And then the other factor that I want you also to put in mind is on bail and detention as a last resort with child matters. Then I also want you to have at the back of your head about issues on privacy and record sealing, and issues to do with sentencing constraints where you can't impose no death penalty, life imprisonment to a child, and offenses committed when one was still a minor, then death and life imprisonment to minors, then why the 16 counts? Is the charge sheet overloaded? So those are the issues that I want us to have a look at. Okay, because the next blog is still associated with Utumishi Girls, there is a matter arising that when the children there is a term known as they are not called suspects, subject. When the subjects were detained waiting to be availed in court, they received threats. So they have received threats, and now I also want you to have a look at how that will implicate or it will inform you as the magistrate, maybe to a point to consider. So I've laid before you some issues, so I want to hear from you. From the issues listed before you, how can you address any of the issue that you feel you are comfortable to address? Then we will clarify with the answers that I had also prepared. Yes, Wilkista.
Okay, Victor, on the issue of arson in schools, I guess we should be able to look at what offense the children are supposed were charged with, or rather were supposed to be charged with, and then we also look at the possibility of the court finding that they were guilty of that offense. For instance, if we look at the previous arson cases, let's look at the one for, was it 2017? Yeah, the one for the TWG case. So in that case, the girl was charged with murder, but the court found that she didn't have the menstrual. So they charged her with, the court found for manslaughter and sentenced her with 5 years. So in this case, we are supposed to look at whether the 16, was it 9 or 8, whether the Masamani subjects.
8. There are 8 subjects, yeah.
Yeah, whether the 8 subjects had the menstrual in the first place, and the possibility of the court finding that they committed the offense of murder, and if not, whether the court will find that they committed manslaughter. So that's the first issue in that. And then we are also supposed to look at the issue of, you spoke about the interest of the children in that they were being threatened. And we can see this was applied in where the court was trying to transfer them from the police station, the place they were, the custody for the children they were in, so that they come to Nairobi because of the threat. Another issue that we can look at is the issue of bail and bond applications. In our case, we can see that they had made an application for bail, but the prosecution counsel objected, saying that they hadn't finished with investigation, so they were seeking for extension of 30 days for the kids to be held in custody as they try to investigate further on the case. But now the court didn't grant the 30 days, but instead granted 21 days. So we can look at, and the other reason, one of the reasons why the court didn't grant the bail application was because they were trying to protect the children from the public. So that's the issue of threats also comes in. So we can look at when the court can grant bail and when the court can refuse to grant bail applications based on that ground. Those are some of the issues I can think of.
Thank you, Kista. Any other member who can raise something? Yes, Chedwick. Yes, Martin, followed Chedwick, then Martin.
Okay, also maybe to add, in such cases of children in conflict with the law, we tend to first of all define who falls under the category of being defined as a child, and also we look at the best interest of the child principle, and also Article 53, which talks of if detentions will be the last resort, first of all they need to explore other means, and also when the DPP approved murder charges, we tend to check if the child falls under category of distinguish between good or bad, if he or she knew what she was doing. So and also the main statute here to look at is the Children's Act. So that's what I can add.
Thank you, Chedwick. Martin.
Can you hear me? Hello.
Yes.
You can hear me. All right. Now I will be able to look at it from two perspectives, not adding what other people have said. Especially on children in conflict with the law. The fact that if you look at the mens rea, what were the intentions of them starting up the fire? For them, they just wanted to break out of the school and go home. So, but of course, that is something that is still under investigations. But more so, I will also be able to look at it from the other angle of the well-being of those the accused, looking at their right to bail, and also looking at the fact that they need to also get some mental counseling, because even for them, they must have gone through, they're going through some mental, psychological challenge, given that if you look at even the previous cases that have been there, then you expect as a child the fact that you are being accused of murdering your friends, people that you know and all that, of course it must be having a mental weight on them. Then the last thing that I would also want to be able to look at is the aspects of emerging issues on health and safety, maybe probably the enforcement of Occupational Health and Safety Act, in the fact that what are the safety features that have been put in schools to ensure that in the event of a fire, then there are proper fire exits that are able to be easily accessed from within. I think I'll be able to look at it from that aspect. Thank you.
Thank you so much, Mr. Martin. Isaac.
Yes, thank you for the chance again. There are a couple of legal issues that could be deduced from this Utumishi fire, which relates to children. First, I could think of the privacy of the victims overall, the subjects. Sorry, subjects, suspects in quotes, subjects as you rightly put it. First, the Data Protection Act and the Children's Act protects publishing, prohibits publishing of the images of the the suspects or of the subjects. So that attracts a fine. So we must start from there first. That even though they are suspects in this matter, their faces or their publishing to the public of their images is prohibited. That's one. Second, now after arrest, then the aspect I could think of the aspect of age of the offenders, whereby the Children's Act talks about children below the age of 12 being not capable of committing any crime, and those in the bracket of 12 to I think 14, correct me if I'm wrong, 12 to 14 being also presumed not to commit a crime, but in case of the prosecution can prove otherwise, then the court may consider. Remember that the age of 0 to 12, that's irrebuttable, but 12 to 14, if the prosecution has means of proving the contrary, then that's admissible. And the age of 15 then to 17, they are termed to be in conflict with the law. I think that you'll explain that baadaye. Okay, third, I could also think about their detention, of which, as I think it's with Kiso put it right, that the detention should be as a matter of last resort. Somewhere in Article 50, here, the right to arrest a person, of course, states that arrested persons or those, okay, not 50, 49 arrested persons, that there should be safety in wherever they are detained. So I think that informed the transfer of their matter from Nakuru to Nairobi. That's one. Two, they should be held separately from those serving the jail times. And the children also held subsequently in children's centers. And lastly, the last legal issue that I could think about is the fact that in the prosecution of the further sentence of these minors who are in conflict with the law, the sentencing should be, or the criminal procedure that they should be put through should be concentrated more towards rehabilitation and not punishment. So rehabilitation, that means number one, they couldn't be sentenced to death, they couldn't be sentenced to life imprisonment, and etc. I think those are the things that I could think about. You can take it from there. Asante.
Thank you so much, Mr. Isaac. Mr. Martin, your hand is still up. Kista, your hand is up.
Okay, I also thought of something. Another issue that came up was the admissibility of the CCTV footages, as people were raising concerns that the evidence violated the rights to privacy. So the concerns were whether that evidence will be admissible with regards to Article 54 of the Constitution. So the question that comes up is, what happens if the evidence is struck out on that basis? And what will the prosecution counsel argue so that to ensure that the evidence is not struck out? Because we are aware that that's the main evidence the prosecution would like to rely on. I saw Lispa had raised her hand. Maybe she can say something on that as well.
No, it's not an answer to your question. So actually, I had the same question with you, but my question was, now assuming we say that this CCTV footage was obtained in violation of the children's right to privacy and stuff, so can court really proceed to maybe acquit the children and say that there was no sufficient evidence when, like, everybody in Kenya, the public itself, we have already seen the evidence and incriminate the kids? Is that really allowable in Kenya, considering that there is no other substantive evidence?
That is well captured. Lispa, any member who would like to attempt, can an illegally obtained evidence be used in Kenya to convict? Yes, Mr. Isaac.
Yes, thank you again for the chance. That issue of illegally obtained evidence, there's a time that whole aspect about the CCTV itself, there's a time I was talking to some senior advocates and they rather had an interesting look at it. And they were of the view that CCTV can't actually be admissible before court. And if it is, its contribution towards the conviction of the minors could be so little. Here is what they had to say. Number one, when you looked at that CCTV, it was centered in the corridor of the cubes. It was inside the dormitory, yes, but it was in the corridors. So if there could be no students who were sleeping in the corridors, then that actually could be a corridor and that CCTV could be admissible because then the right of their right to privacy could not have been infringed. Remember, Article 50 states that illegally obtained evidence that is obtained through contravention of any right. I think I could have. Yes, as I look for it happen. So they said that there were beds in just below that CCTV. There were beds below it. So the presence of beds converts now the corridor to be not just as a corridor, but also as a queue because there were students sleeping there. So actually, their right to privacy was violated, which brings another question. Nobody disputes the credibility of the evidence. It's not AI generated. It's not false. It's not a matter of dispute. Now, can courts compromise the rights of victims or of the perpetrators? Either way, to make ends of justice meet, where the credibility of the evidence is not disputed. What is disputed is shame.
Yes, am I allowed to speak or we just let the speaker go on?
No, you can correct me if you can contribute as we move.
Yes. My point of contention, and sometimes I believe that this evidence could be admissible, is if the parents of the institution were informed that for the security of your children, we want to have the CCTV coverage and we are seeking your consent, and the parents signed the consent form. Now, if we find the parents sign the consent form to allow the institution to be a data controller, I want you to now speak in that context, that the parents have already signed a consent form, and then they are aware that the CCTV, they are covering the dormitory of these students for their security. How will you go about it? Thank you.
Good. So can I also clarify as a contributor too on that point? Now, Mr. Isaac, about the illegally obtained evidence, I have analyzed Supreme Court decisions and Court of Appeal decisions, and what I've realized is that they are following a strict test that it is any evidence obtained through the violation of the constitutional thresholds, it will be unfair. And for it not to be used, they usually use a certain test. And this test is a two-stage test that has been obtained directly from Article 54 of the Constitution. What they will do, they will ask Kwanzaa, is this evidence leading to an unfair trial? 2, is this evidence leading to the detriment of access to justice? Now, in doing so, the Supreme Court sana sana ndio imeemphasize that I'll send a decision to, but this one was a High Court decision following precedents from the higher courts. And in this decision, it was a divorce proceeding, and the man allegedly had installed secret CCTVs in their bedroom. And it is this CCTV footage that he was introducing to court to show that this lady was having affairs, secret affairs. So that was the only source of evidence that he had. Now the court had to apply the test, and it said that you can't come before court and say that because this evidence has been obtained without my consent or illegally, then you now claim the blanket rule. That will not be granted. What the court did, it analyzes all the material placed before it, and it excludes any material that has been obtained illegally via those tests. So if it will be to the public interest, or it will not result to an unfair trial. By an unfair trial, it is not to say that it will affect your conviction rates. That is not an unfair test here. So in this situation, we will allow the court to analyze that kind of evidence that it is before it to the two-stage procedure outlined under Article 54 of the Constitution of Kenya. That is how you are supposed to answer that question. Lispa?
Thank you for that decision. It actually confirms my thinking. Juu, I was seeing if your section, not section, Article 54 may provide your exclusion clause here, it would be detrimental to the administration of justice, then I don't see how using your CCTV itakuwa detrimental to administration ya justice ya how the accused person, yet it has captured anything private kama maybe the students wakiwa naked or something, enye imekuwa released ni hiyo bit ya wakiplan the fire. And also I feel like if we exclude the evidence, itakuwa detrimental to administration ya justice to the victims as opposed to how the accused persons.
Thank you so much, Lispa, for that. Any other contribution before we analyze what I had prepared?
I had not finished what I was saying. There's a matter, I can't remember its citation, but I think it's Okiya Omtatah versus Attorney General, one of the many Okiya Omtatah versus Attorney General, which was about the SGR, and it properly handled the issue of illegally obtained evidence. However, Okiya Omtatah showed up with bundles and bundles of documents which showed how there was illegality in procuring the tendering process and all the illegalities zenye zilikuwa zimehappen kwa hiyo nini ya SGR, hiyo tendering ya SGR na vile do ilikuwa imeibwa. So he showed up with them in court and he said that he had been given by an insider from Kenya Railways. Now the issue arose in court that this is the only evidence supporting this case. These documents zenye Okiya Omtatah amekuja nazo. Yes, I think somebody has pasted its citation in the chat. This is the only evidence that is admissible in that supports this case. Just like the utumishi issue, because the last time I checked, hawakupata nani alisnikisha hiyo mafuta ndani ya shule na alinunulia watoto ama vile hiyo mafuta iliingia. Na actually hiyo CCTV inaonyesha tu wakitupa kitu chini na waka. It doesn't show they are planning nini vile wanamwaga mafuta vile wanawasha vile it's a quick thing. But remember, this is the only evidence. Okay, there could be other supporting evidence. There are witnesses and all things, but this is the main one, in which its exclusion could impede the administration of justice or the victims from getting their justice. So it was the same from the matter ya Okiya Omtatah. I don't know if Ulkista has read it. I don't know if Ms. Kisa has read it so that she can tell us what it entails, because it's a case that is very essential to this case. It's a copy paste actually. Kisa.
I haven't read it, but it was a Supreme Court decision, and that's the position right now in Kenya, whereby any evidence that is illegally obtained or obtained in contravention of rights cannot be admissible. Because we also have the other case for Njonjomwe and another versus the chairperson of IEBC 2017, where the court also say that you can't use illegally obtained evidence. So I haven't read it, but we can go through the case and see what the court had to say.
Sawa.
Sorry. Yes, Isaac, is it additional ama we go straight in?
No, I think we can save time and proceed.
Sawa. Thank you all those considerations are very vital. So for my end, I want to give the various enabling provisions to support various answers. So if you read section 228 of the Children Act, this is a substantive provision that provides that the offense of various elements that involve a child will also be subjected to an age determination criteria, where we will have a mental assessment, a physical age assessment by specialists to determine their age, so that they place the children accordingly to their brackets. Then if there is a substantive charge, the substantive charge will still fall under the enabling provisions of the Penal Code, section 203 and 206, but we will explain later why the charge will reduce to murder. I've also attached various decisions, Republic versus Zakaria Mohammed 2019, and in particular this is an issue on birth certificates and age assessments and how the same can affect bail, because bail cannot be granted immediately where the age has not been resolved and there is other pending criminal custody issues. Okay. Then we also have another decision known as JMK versus Republic, where when do you assess the child status? Do you assess the age at the offense date or on the conviction date? The answer is at the material time of commission of the offense. The offense date is when you assess the age. This is very important because it now answers the second question that I asked you, where a person committed an offense while still a minor. Then when it comes to the conviction part, he has attained the age of majority. What usually happens? So the material time of committing that offense, he was still a minor. So the minor guidelines will still apply to him. Now, another key takeaway that you must understand is that in section 218 of the Children Act, it tells us that the police must notify a parent or a guardian and an authorized officer, being a children's officer, within 24 hours. And then children officer must conduct assessment in a child-friendly environment. So those are the preliminaries. Whenever you are told if you are the arresting officer in this situation, what are you supposed to do? You are supposed to immediately notify the parent or guardian and also notify a children officer. Haya. The other key takeaway we can see in Republic versus JKK 2022, and the issue was whether the pre-bail or probation material was adequate for a minor, and the court granted bond but required further structured reporting and commitments. So this is important because we have seen this case postponing the bond or bail consideration on grounds that they want to do what we call preliminary inquiry before any bail or bond is issued. And by doing so, they want to interview the parents, the school, to hear their reports, what they will be saying, because it is a requirement factor. And also, if you read section 228 of the Children Act, it goes further to say that a preliminary inquiry preliminary inquiry is mandatory prior to plea bargain, except where the child is below the age of 12 years or the matter has been withdrawn. And in this situation, the preliminary inquiry before plea is taken is important because we will have various issues like placement of this child, participation of the child and their parents, and diversion possibilities. Remember, I told you that you can be asked in orals what is the explanation of diversion. Diversion will happen when the prosecutor exercises his powers, the DPP exercises his power to take a child from the normal criminal trial procedure and put him in other rehabilitative methods of punishment. When they are maybe even their mental health is not stable, they have that privilege to do that. Then other key takeaway, remember these are decisions zenye nimelift. Yes, bail for minors charged with murder, like for instance the Utumishi tragedy. Compelling reasons are still required and terms must be child appropriate. This is in compliance with section 223 of the Children Act that tells us as much as possible that bail for minors should be given unless there are compelling reasons, and detention should be the last resort, and where bail is to be denied, this child should not be taken in a detention facility together with adults. They are taken out to a separate facility for children. So that is it. So all these decisions are to support those allegations. And the other issue that I also addressed was on the issue of privacy. And when it comes to privacy, section 220 of the Children Act is the one that has directly prohibited the release or publication of information that may identify a child offender, and it creates an offense. I had a participant saying that this provision is provided under the Data Protection Act and you will be fined. That is wrong because it is an offense and it is provided under section 220 of the Children's Act. That is it. All these are decisions to support that environment. When it comes to substantive charging issues, where arson causes murder, we have seen the court saying that the children will not be subjected to a murder, but it will be. There is a potential to have the same reduced because of when it comes to sentencing aspect of it, you can't give a death penalty to a child. Then there was an important decision that was shared in the group by Ringera, and Ringera told us that when it comes to such cases, malice aforethought discussion is usually taken from conduct and circumstances, and he went further to give a situation where a child had even scribbled some words on his locker saying that they want to leave this school, they want to burn this school. All those are elements that will form a malice aforethought for it to apply. Now, the other consideration that I also asked you to consider was on the issue of a minor offense, a minor who committed an offense while a minor, but it comes to sentencing, that one I've clarified. But on the issue of 16 murder counts, you can be asked that. You know generally that criminal matters, criminal charge sheet should contain not 12, approximate 12 counts, not more than 12 counts. But in this situation, we are seeing 16 murder counts. Is it overloading? Yes.
Victor, that position of murder charges 12 counts is no longer the position. See, I don't know, it was in Ochieng something case. Yeah, the court clarified it in that case. Yeah, huyu mtu wa kuua watu anaitwa nani sasa? Huyu
Mackenzie.
So, because yeah, Mackenzie case, because walikuwa wana argue that your charge sheet yake iko overloaded. I think it's High Court ili agree with that, but the Court of Appeal ilisema that the charge sheet was not overloaded and they can't say that tutaweka 12 charges because now what happens if we charge when you are the 12 counts? So what will happen to the other victims? How will they get justice? So that position, 12 counts is no longer in place.
Thank you. That was where I was also coming at, because this is an exception to also in support of Paul Mackenzie decision. And before I reach there, we can see Section 221 of the Children Act also telling us directly that the Children Act applies even if the person turns 18 before the case ends. Then there are some sections that have also incorporated there that the Children's Court jurisdiction excludes murder, but whichever court hears it must still comply with the Children Act safeguard. This was a point that was raised by a participant previously, who told us that matters to do with children should be heard before a children's court, but in this situation for Tumishi, we are seeing them being taken to the normal magistrate court. Now, the Children Act, in particular Section 91(2), says that even if you are to take this child to other courts, you still have to abide by the laws of the Children Act. Okay. Then Section 238 of the Children Act is the one that has directly prohibited or restricted the punishment for a death penalty for children. All these are reiterations. Then another rationale that you should take note of is that the best interest of the child should also be considered. Now, why are we having 16 murder charges in this situation? And the answer is here. Let me show you here. Because this is a proper joinder of multiple counts, because it is allowed where offenses are founded on the same facts, same transaction, because the law requires each offense to have a separate count. Now, you will tell the panel that you know the difference between overloading of a charge and what we call duplicity. It will have been a duplex charge if they could have charged more than one offense in one count. If they could have inserted arson as read together with also causing murder in one count, that is where you will clearly point out to the panel that could have been now a bad charge. So up to that point, I believe we have exhausted that angle. We have also discussed on the issue on threats. They have received threats while still under a children's facility, and then the magistrate asked one question: who allows such kids to have mobile phones? Because they are saying they have seen their images online already circulating, and people have identified them, and they are sending threats to them. So the magistrate has told the children officer to note the individuals who are circulating these phones to these kids, because it is affecting their mental capacity, and they will have to undergo another assessment before the issue on bail comes in. They will have to undergo another assessment to test their psychological position pursuant to that fatality. So it reveals a weakness when it comes to the children's officer and the facility. The magistrate is likely to also order the children to be transferred from that facility and be taken to another place. All these are reiteration. That's why I'm skimming through. I'm skimming through because we have discussed the same. I've also explained why the law allows for postponement of a bail ruling, because you are giving room to hear many reports as much as possible, what we call pre-bail materials, including victim and community input. This is exactly what is happening in the Utumishi Girls fire tragedy. So that is it. Now I'm going to discuss various landmark decisions, about 3-4 hazikuwa mingi because of the factor to time. This year we have seen a decision known as Rigathi Gachagua. So the honors is upon you. Have you had an opportunity to read through the Rigathi Gachagua? If you have read through the Rigathi Gachagua decision, you can briefly tell us the key takeaways from this decision. what are the issues before court and the rationale, then we go to another decision. This question is a very a good prediction. If you have not yet read Rigathi Gachagua, that means you are likely to be asked this question na inaweza kupata mahali pabaya.
Oh, Victor.
But
Hello. Can you
yes,
hear me?
Mr. Arnold, you are very audible.
Oh, niko fiti pia. Okay, about Rigathi Gachagua. Oh, Rigathi Gachagua case. Please. So the audience. Okay, let's say first. Okay, for me, the first name. Okay, as in the way I understood it, it was a consolidated petition. It was challenging the impeachment of the deputy president Rigathi. It was challenged Professor Kiteki, and it was decided by the three judge bench. By the way, who was Ogola, Mlima, and Mugambi. Okay, on the holding, the first issue, okay, they overlooked about the jurisdiction of who could have handled that case. So, on that issue, about the jurisdiction, the court held that the matter can be resolved by a court of law. It also stated that even though in power under Article 20
On a break.
under of the Constitution. What about now? Can you hear me? Hello?
Yes, now you're audible.
Okay. The court held that even if the impeachment is a political process, the court retains power under Article 23, 24, and 165 of the Constitution. So, if you look at I've stated under Article 22, 23, 165. So, under Article 22, under Chapter 4 of the Bills of Rights, Article 22, every person has the right to institute court proceedings claiming that a right or a fundamental freedom in the Bill of Rights has been denied, violated, or infringed. 23 continues to say that the High Court has jurisdiction in accordance with Article 165 to hear and determine applications for redress of denial, violation, or infringement of the fundamental right, freedom and right. Then 65, obvious, is the judicial one, and it established the High Court to be the court that has unlimited original jurisdictions. So, in our case, they determined that the High Court, the three judgments were eligible to hear that case. So, the next review was because there were 7 issues. about the public participation. In public participation, okay, it held that the National Assembly and had done adequate public participation. And again, it is stated that no public participation was needed for nomination and approval of Professor Kindiki. They also challenged the standing orders on the
Arnold, you're breaking.
court.
Am I the one breaking, Amani Arnold? Lisbeth, can you confirm?
It's Arnold.
It's him.
Court
Arnold, you're breaking.
both house, check the net. Okay. Yeah, tulikuwa kwa unanisikia? Victor?
Yes, tunakusikia sahi. Tunakusikia sahi.
Then hiyo ingine ilikuwa about the issue of IEBC. The court declined to find, okay, the court found that the National Assembly, okay, it held that IEBC input was not constitutionally required for the midterm deputy president replacement. And they upheld that Kindiki nomination and appointment was valid. Then they also challenged the process of impeachment of the deputy president. And the article, okay, impeachment of the deputy president is under article 150, the removal of the deputy president. Okay, and article 150, the removal of the deputy president. Okay, there are many issues that a deputy president can be removed from office. Maybe the first one was, let's say, the physical and mental incapacity to perform the functions of the office. Then, in our issue, the main one was on impeachment, on the grounds of gross violation of provisions of this constitution. 2, where there are serious reasons to believe that the deputy president has committed a crime under national or international law. Then the third and the last for gross misconduct. Okay. Here, okay, in the removal of the deputy president, the parliament is required to enact a legislation under Article 152 on the removal of the president. Yenye inafaa kuendanisha na the removal of the deputy president. So, although there was no registrations, there was no parliament enactment or legislation on that matter, the court will determine it was not necessary, but request the parliament to do it as soon as possible. Juu ukiangalia the removal of the president under ground 144, where a member of the National Assembly, supported by at least a quarter of all the members, may move a motion for the investigation of president physical and mental capacity. Also, if we continue to Article 145, it is the removal of president by impeachment. So, the removal of president and the removal of president ndo inapeana guideline for the removal of the deputy president, but the parliament first should do a legislation so that it can be under guidance of the removal of the president, because in the constitution hakuna mahali parliament imekuwa guide, hakuna mahali kuna guideline ya kuremove the deputy president directly. So wanna follow the procedure removal of president by impeachment ndio wanatumia. Hiyo ndio inakuwa guideline. So hapo now hakukuwa na enactment kaa hiyo ama hakukuwa na legislation kaa hiyo. So the court ilisema hata kama parliament haijafanya back legislation si important sana, but ili advise parliament as soon as possible wafanye nini, wafanye hiyo enactment. Then the last ni yenye ilikuwa as in it was in favor of Gachagua about the fair trial. Fair trial iko under Article 25C in accordance and the fair hearing iko under Article 50 of the Constitution. So hapo ndo the court ilipata the right that the right that were violated and those which was the to a fair trial, which is under Article 25C. Then about the fair hearing. Also, we can talk about the fair administrative action, which is, I guess, is in Article 47. Then another one was about the Senate. Now, according to hiyo nilikuwa naongea about the removal of the president, ina require Senate to form a committee to investigate the removal of the president. Hiyo ndio itakuwa guideline ya removal of the deputy president. But wao they did not form a committee. So upon the court ilipata the right of fair trial and fair hearing of the former deputy president was violated. Yeah. I guess those 7 issues. Then nimeelewa about it kidogo. Okay, Victor, you can take over.
Thank you so much, Arnold, for that discussion. Sasa unaona umesoma in detail. Now this is the summary that I also tried to prepare. That the High Court judgment upheld the validity of Rigathi Gachagua's impeachment because it refused to quash the Senate resolution, but found the Senate violated his fair hearing or fair trial rights by refusing an adjournment when he was ill and absent, and in return they awarded him 50 million constitutional damages and directing Parliament to enact a dedicated Article 150 implementation framework for a deputy president. What was the case about? The case was about multiple consolidated constitutional petitions that challenged the following issues: the National Assembly process leading to the impeachment motion, the Senate trial. Kuna mtu ameunmute. Ni Arnold. Arnold, kutakuwa na echo. Okay, I've muted you. Okay. So multiple issues zenye zilikuwa zina arise in case ulizwa on your feet. What were the issues at the Rigathi Gachagua decision? The National Assembly process leading to the impeachment motion was also an issue. The Senate trial process and the outcome of removing Gachagua, the speedy nomination and approval of Professor Kithure Kindiki as a replacement of Deputy President, and alleged lack of public participation, bias, invalid standing orders, IEBC capacity, and gender rule issues. What were the key holdings on your feet? We had the issue, the holding on jurisdiction. The court held that it had jurisdiction to review impeachment processes for constitutional compliance, testing on rights and procedures, but not to sit as an appellate body on political merits. Okay, hiyo ilisema directly. Point number 2, ilisema that allegations of bias against speakers, MPs and senators were not proved to the required objective threshold. Hakuweza kuprove your element. Then on public participation, the court said that the National Assembly public participation was adequate and met the constitutional threshold. The Senate was not required to conduct a second independent public participation exercise at the trial stage. Public participation was not required for the Article 149 process of nominating or voting in a replacement of a deputy president. So it didn't require public participation for purposes of Article 141 procedures. On the issue of standing orders, the court said that challenges to the National Assembly and Senate standing orders were rejected. The court did not strike them down. On IEBC and nomination of Kindiki, the court held that IEBC clearance was constitutionally required for a mid-term deputy president replacement under Article 149(1), and that the speedy gazettement and nomination and the National Assembly vote did not itself prove illegality or predetermination. The speed of the whole process did not prove an illegality or predetermination. It affirmed Kindiki's nomination and appointment as valid. Then the issue on special committee versus plenary in Senate, the court accepted that per binding Apex Supreme Court guidance referred in the judgment, the Senate could proceed either by plenary or special committee. So failure to form a special committee did not invalidate the process. This point has also been captured by Arnold. Failure to form a special committee did not invalidate the procedure. Then on issue on fair hearings, the court found that Gachagwa's fair trial or fair hearing rights were infringed when the Senate refused an adjournment and proceeded despite his illness and absence, creating an unfair imbalance after the National Assembly had fully presented its case. Now, what are the remedies or orders that were issued? The court refused to quash the Senate impeachment resolution, and thus the impeachment stood. Issued a declaration that Gachagwa's fair trial rights were violated by denial of an adjournment. Issued a declaration that Parliament must enact a dedicated statutory framework for Deputy President impeachment under Article 150. It made no findings on pension or emoluments because these were left for another forum. It awarded 50 million constitutional damages payable by the Senate for vindication or dignity and not loss of office compensation. That is very clear. You must tell the panel that this amount is not being awarded to Gachagua for loss of office compensation, but for vindication, deterrence, and dignity that he was subjected to. And each party was to bear their own cost because it was a public interest litigation matter. Now, we also had another landmark decision about the unconstitutionality of various sections of the Computer Misuse and Cybercrimes Act. What's in your view? Did you have any time to read through that decision so that we break it down for us to understand? Okay. By the silence, it means that this decision could have gotten you off guard. So basically, this is the case of the Law Society of Kenya versus the Honorable Attorney General and Communication Authority of Kenya and two others. The consolidated petition challenged the constitutionality of key amendments that were introduced by the Computer Misuse and Cybercrimes Amendment Act of 2025. Principally, you should state them. They had decided to introduce that the new power given to the National Computer and Cybercrimes Coordination Committee under Section 61JA to issue directives rendering websites or application inaccessible. That is one element of it. That the power to declare websites or applications inaccessible. And also the other power was on the amendment to section 27(1)(b) that sought to criminalize communications that are likely to cause a person to commit a suicide. So the petitioners argued that those amendments were vague and overbroad and will chill constitutionally protected speech and amounted to administrative prior restraint because an executive committee could effectively block online content without prior judicial authorization. They also alleged defects in the legislative process, including failure to involve the Senate and lack of a meaningful public participation, and that the respondents opposed the petitions, arguing that some issues were already determined in prior litigation, including involving the Bloggers Association of Kenya, and should be treated as bad by res judicata, and further contending that the amendments were reasonable and justifiable limitations of right under Article 24 of the Constitution. Now the court held that the res judicata applied only partially, because the challenges that effectively re-litigated provisions and issues already upheld in earlier Bloggers Association of Kenya litigation could not be reopened, but the court could still scrutinize genuinely new issues arising from the 2025 amendments and the process of enactment. Now, the gist of the takeaway is that the court rejected the Senate and public participation challenges, finding that the amendments did not concern county government functions and that the parliamentary record showed sufficient public participation, including on the specific amendments to Section 6, and on substance, the court declared unconstitutionality of the provisions of Section 6(1)(j)(a) because it conferred sweeping power on the National Computer and Cybercrimes Coordination Committee to block websites or applications without judicial scrutiny or adequate safeguards, despite the statute also providing a court-supervised mechanism for a similar relief. And the court also struck down the likely to cause suicide limb in Section 27(1)(b) for creating speculative and indeterminate criminal liability inconsistent with the constitutional requirement of clarity and foreseeability in criminal offences. Each party was ordered to bear their own costs. So those are the key takeaways, very crucial takeaways that you can be asked on your feet by the panel. So we are approaching now the second last decision, and then we call the session off. So this is how we will be blending with current affairs. Then for current affairs, they will be informal in a way. Now, this is the decision known as the Anthony Otiende versus Public Service Commission. This decision was sent by Will Kister in the group, and I want to know whether people took time to maybe even go through the same, or they just brushed it through. I just need the key takeaway in this decision, then we see what the other decision talks about. Because Kister told us that this is usually tested by one of the panel lecturers. You can appear beforehand, then you are asked such a decision and you didn't have a look at it. Can anyone remember Will Kister trying to explain the same? Chedwick, yes, Chedwick, you can summarize it down. Yeah, and 2 minutes.
Okay, basically the issue before the court was about the legal notice that was to supplement the Land Act and the Land Regulation Act. So that's legal notice from 277 all the way to, I think, 280 or 290 something. So the court had initially declared them they were unconstitutional, if I can use that term, and the court had given the Ministry of Land a period of 12 months to implement, to effect changes, to give effect to that ruling that was delivered. But the 12 months had lapsed, and the ministry had moved to court to seek more time, 6 months, since they say that the issue was before Parliament, which was during the electioneer period, so they did not have, it was beyond their control, and the Parliament was heading to the electioneering period. So the court acknowledged the fact that the Land Commission had no control over what was before Parliament, and hence the prayer for the 6 months was allowed because the court exercised judicial discretion on the same. So Antonio Tiende moved the court to challenge the Ministry of Land for relying on the provisions of the legal notice that were declared unconstitutional, and the court had extended the time that was being requested by the Ministry of Lands for 6 months to enable the changes to take effect. So that's what I read. Because there were two cases on the same that were sent. I think that one was a ruling or something that I had read. Thank you.
Good, thank you Chedwick. Sasa wewe ulienda ukasoma ruling, but now the panel will be interested in the judgment because the ruling was just to seek extension of time, but now the judgment categorically said that the nature of how these regulations were passed, they never complied with the National Land Commission's advice. They never requested for public participation, and this matter was tabled before Parliament. Was never tabled before the Parliament for scrutiny and approval. So in short, the Cabinet Secretary for Lands acted ultra vires, and thus the same were declared to have been suspended for invalidity for a period of 12 months to avoid ongoing land registration, because there was a lacuna for those forms because the previous regime had also been repealed. So that was the key takeaway in this judgment. The Cabinet Secretary acted ultra vires without taking into account the three conditions that I've outlined. Then lastly, what is this decision? Moi Teaching and Referral Hospital versus Dr. Macharia Gikenyi, 2025, a latest decision. A decision that we also discussed during the course of the day. It's from the Supreme Court. Any member can attempt, just briefly, because it is something that we also discussed. This is just to emphasize on some key aspects. Who got the key takeaway for this Supreme Court decision? I can give you a hint. It is about the ELRC versus the High Court.
Victor, maybe I can attempt. I haven't heard the case, so this is based on what you told us. So the issue was whether issues concerning recruitment could fall under the jurisdiction of the ELRC, or they were bound to be heard by the High Court. And now the previous position was that the High Court was the one that was supposed to hear those cases. But now the Supreme Court said that issues of recruitment fall under the employment regime, so they are supposed to be heard by the Employment and Labor Relations Court, moving away from the previous position. On the issue of the High Court, I am not quite sure.
Thank you, Kista. Somebody had also raised up his hand. Dr. Shem? Yes?
Yes, I can also try. I hope I'm right in whatever I say, and if I'm wrong, you correct me. There was also another issue that was, or maybe just to add to what my sister said, there was also a question that normally courts always considered whether who has come to the court. For example, is it an employee who is complaining on, for example, on an employment issue? Then that matter will automatically go to normally the employment court. But I think now the Supreme Court came with another format or approach of determining where does a person go, whether it's High Court or the Employment and Labor Relations Court. Now, I think now you'll give us a very good elaboration on this. Thank you.
Thank you, Shem, for that theme. Mr. Martin?
Thank you, Victor. I think for me, probably I will talk of the exclusive jurisdiction of the Employment and Labor Relations Court, meaning that the High Court cannot be able now to tackle those matters, and you're looking at all the way from the pre-recruitment in terms of shortlisting, in terms of all that, all the way to the recruitment process itself and all those appointments, and also labor relations issues, which now exclusively these decisions have exclusively put them under the ELC.
Thank you, Mr. Martin, also for that attempt. Now let us seek the clarification of what the Supreme Court actually did. It is a very brief discussion, then we will call off the session. So before you'll note that the decisions are ziko mingi, nimecombine mingi za 2026 na zote ni landmark, so don't worry, we will be analyzing when it comes to current affairs. Now, the case summary is that the Supreme Court has clarified the forum for challenges to public sector recruitment. It has categorically held that the ELRC jurisdiction is not confined to existing employer-employee relationships and can also cover pre-employment recruitment processes like advertising, shortlisting, interviews, and selection, as per Martin Venyametuambia. However, on the particular facts before the Supreme Court, it still held that the High Court at Nakuru could hear the petition because the petitioners had sued a public interest matter in their capacity as citizens and human rights defendants, but not as the applicants or prospective employees, or not on behalf of unsuccessful candidates. The court partially allowed the appeal and cross appeals, setting aside the Court of Appeal's restrictive view on ELRC jurisdiction, but leaving the High Court's assumption of jurisdiction intact in directing the Nakuru petition to be heard on priority. What was the rationale? The court reasoned that Section 12 of the ELRC Act is non-exhaustive, and read together with related labor statutes, it shows that ELRC jurisdiction extends beyond the classic employer-employee disputes. In particular, the Employment Act treats discrimination in recruitment as an employment matter and defines employee to include an applicant for employment. So, pre-employment disputes can properly fall within ELRC's mandate. That was the rationale, because it is a direct interpretation of Section 12 of the ELRC Act and Section 5 of the Employment Act. But because the petitioners framed their case as a public law constitutional challenge brought under public interest standing, but not as job applicants, the High Court retained jurisdiction for that petition, even as the court corrected the broader, previously narrow understanding of the ELRC jurisdiction. That is the key rationale that you can be asked on your feet. Why did the Supreme Court hold that? It held that way because the Section 12 of the ELRC, as read together with Section 5 of the Employment Act, is to be read in a progressive manner. It is not a limitation imposed to the jurisdiction of that court. Rather, it continues to tell us that discrimination can also happen during recruitment. So pre-employment disputes automatically can fall within ELRC's mandate. So that is how you will interpret that case. Now the panel will see actually what was happening in this decision. So up to that point, I would like to request for any closing remarks, any comments, by the way. How is this model suiting to you? Where should I change? Where should I improve? Your suggestions are greatly appreciated, because this is a new tooling you may bring on board. If it's current affairs, tunapiga current affairs, tunaangalia mpaka decisions.
I have really enjoyed it. It's a wonderful, wonderful session.
Thank you so much, Shem.
Victor, this is excellent, very good, very good approach, I must say. And I will really urge that you keep the tempo and keep us in the know. Thank you.
Thank you so much, Martin. Thank you so much for your suggestions. Then, during our previous meeting, ni mzuri niwaambie what new model was introduced. A new model was introduced yesterday night because people said, in as much as we are learning how to do drafting, in as much as we are learning the principles at our fingertips, we don't know how to actually draft within a shortest period as practical as possible. Now, there was a suggestion ilisema, on Monday, tomorrow, I'm giving out a list of documents for us to familiarize ourselves with when it comes to the drafting aspects of the same. Tuangalie, for instance, nataka niwatumie deed poll. You check on the Registration of Documents Act instances where you will be drafting a deed poll. Kama ni divorced wife, kumbuka kuna pale statutory declarations, kuna zingine zinaenda na affidavit. All those small minute details nataka mpitie, so that wakati tumesema mpitie deed poll, wakati nimesema mpitie how to draft a charge sheet, na nikasema nitawapea pia how to draft a duplex charge sheet, how to draft an overloaded charge sheet, how to add an alternative count. Haya, hiyo itakuwa exercise number 2. Uzuri ndazilist, ndawapatia kama list. Si mingi, bora ni for that week. Alafu the other instrument to draft tukasema itakuwa initial notice, amendment notice na cancellation notice. So unapata this list itakuwa imecapture one document per unit for that week. So when we will be meeting on Friday, tuliagree Saturday ndio tutakuwa tunafanya the review of these draftings. And what will be happening is that people in the law firms wakuwe na the practice documents kwa field. They can omit some key details for confidentiality, so that wakati wanakuja kututumia, wananitumia kama sample to project, we analyze kwanza the requirements, alafu sasa tuangalie this is the practice document, how it appears, ikiwa imefichwa the confidentiality elements. Why are we doing this? Kuna mtu alisuggest akasema, whenever unafunzwa a theory drafting venye huwa tunafanya, it is very okay, but wakati tunaingia ile session nikisema now let us draft a deed poll with the following information, tunaweka tu random information pale, just an activity. Kumbuka ni the whole Saturday, so automatically watu wako online classes, class G members, sijui what you will be doing. Juu sasa is either mseme Saturday mchana ama Saturday usiku, whichever yenye mtataka. Juu what we want to implement is a practical approach to this document. Sasa how can we be drafting them? Nikisema deed poll, sasa tuandike. Unachukua kalamu mahali huko, unaandika, unatuambia tebu tusome hiyo venye umeandika, tebu tusome, tunasikia hizo version. Alafu wakati sasa tuna project the practice document, believe you me, utakumbuka mistake ni ule jamaa alifanya, ule alichonga draft charge sheet yake vibaya, ule alikosea hapa na hapa. Now that template itakuwa not only si ati una cram, itakuwa ni kitu umepractice through ukiwa umesit Saturday usiku for the sake of class G. Tafadhali sawa Saturday usiku, that is what we will comply with. So unapata hii timeline, tunapeana mpaka time ya kudraft hiyo kitu kama madakika to avoid a situation where pia tumedraft one document for a longer duration of time. Nikisema today tuna draft an appellate court, nakwambia mtu anataka kuappeal, anataka kwenda court of appeal, I want you to draft a notice of appeal, a memorandum of appeal on your feet, the grounds nakupatia. Now kumbuka hautapewa pia kwa exam reference material to confirm the sections being violated. So automatically lazima utatusomea kitu umeandika the way it is. Hakuna use of AI to test our writing skills on our feet. So let me send the detailed list of what we are supposed to draft for this week, so that wakati tunapatana nikikwambia draft it on your feet, I assume you went and did a research, ukajua this is how this document is supposed to appear, these are the grounds that I'm supposed to write, this is the language to use. So across all units, ndio tusijipate mahali tuko pabaya. That was the new feature that was introduced. Yes, Mr. Martin Mwenamkono.
No, I was just agreeing with you that some of us in class G and Saturday is a heavy day for us. If we can do it at night, the better. I think night would be very good. If night is too heavy, we can do Sunday. But yes, I know we all want to go to church on Sunday, but yes, maybe Sunday after. We can just suggest.
Good. I prefer Saturday evening. Juu Saturday evening huwa inakuanga siku ya kutransnight. Juu ukitransnight Saturday evening unaweza okoa the weekend on Sunday. Unaona? So alafu pia it is not prejudicial kwa watu wenye hawajajoin, juu watapata recording imenyamaza, hakuna kelele. Hiyo itakuwa mzuri sasa kwa. So we have agreed that it is Saturday evenings for drafting, actual draftings, real court documents na real steps za kuavoid fatality. Juu nilinote wakati nilikuwa naelezea watu the difference between 5(2)B application na the difference between an application being brought under Order 42 Rule 6 ni kitu hata iliulizwa April civil litigation paper. Sasa unapata the examiners wanachukulianga advantage juu many students do not know how to draft actually, but mimi ni kitu nimedraft nikafanya hiyo mistake na nikakorektiwa na hadi wa leo ijainitoka, unaona. So if I'm also I can also be in a position to teach you kitu yenye practice inafanya pia nyinyi naona mtamaster as compared to cram. Kama ni third party nikwambia let us do a third party application, kindly let us draft the necessary application. Tunaanza umechonga chamber summary, umefanya notice of motion na wewe umetoa chamber summary, good, tuna correctiana on our feet, no hakuna blames attached nini. That will be a very detailed session and hapo mtaona fruits zake. Hiyo ni siri nimewaambia. So to that point me I beg to yes. Yes.
Something that I really don't understand how they do it is how you find that one question has like you have to draft like 5, for example, like there's a plane that kuna mtu hajalipa pesa ya gari yenye alinunua, and then now you have to draft all those documents from demand letter to all those. How do they do it in those 3 hours? I hope we will learn how to do it.
Thank you. In fact, ndio nilikuwa naambia watu ukisikiza maswali not maswali, ukiongea tu na mtu na mark hizi exams in a genuine level, unajua hawezi disclose, but mimi najua mmoja kitu aliniambia, students ni kama mnakonga mmeweka life yenu in orals na project. Juu vitu tunakutananga nazo kwa exam, maswali watu wameacha blank. It is a reality. Wewe unajua theory. Sasa pale wanataka unaona swali tu umeuliza, that is the exact thing that happens. Wewe umeenda pale hujui hata the grounds mali unafaa kuziweka, hujui what application to bring this thing under, hujui what is the necessary document to attach to this application. So you end up failing not because hati hukufunzwa, you are taught but you never practiced. Hiyo tu ndio the key identifier, lakini sitaki sisi tukue culprits wa hiyo statistics za kufail main exam. That is the only savior mechanism yenye tunaenda kuweka. We have the necessary documents, niko na templates za law firm, it is just to edit and show you, and by that I will save you a lot. How do you approach the EACC court, a court with a separate special procedure on its own? How do you recommend charges when it comes to EACC? Hizo zote tunaangalia na the practical element of it. Yeah, so I believe any other person mwenye akona suggestion to that? Sawa, Shema amekubaliana. Sawa. Okay, so there were some pending legislations, na hizi legislations tulisema tunajaribu as much as possible kwanza kuperfect our oral aspect, everything in orals tuna perfect, alafu tuna release now the analysis of the legislations one by one, tutakuwa tunazituma pale, tunaziangalia to avoid a situation pia tunabaki nyuma when it comes to analysis kama civil litigation iko nyuma. Yeah, so up to that point, unless kuna any other comment, I will end the recording. So thank you so much guys. Thank you so much guys. Have a good night everyone. The recording will be uploaded for the sake of Viona. The meeting is officially ended.